Well, aren't we lucky? We've had 6 excellent speeches. They've been well crafted. They've made the points. They've been well delivered, and they've kept very largely to time. But it's only you expanded it by referring to me, so I didn't mind that. So we've now reached the stage, ladies and gentlemen, online and in the room, where it's over to you to ask questions or to just make points if you wish to. Looking at Sophie to see whether there's anybody online. In the room first, right? So, right, anybody in the room? Right, Maud, in the middle of the front row, second row.
Thank you. I wonder if those speaking for the motion could expand on the idea of the child's rights in this. A lot of the argument has been around parental rights. I'm interested in the child's rights.
Thank you. Anyone going to?
I suppose I would say, Maud, that a child's social reality should be matched by a legal reality. And so in terms of who they see as their legal parents, they too have a right to have that recognised as well. I suppose part of the problem is that some of the cases that come through the courts mean that the child isn't benefiting from that status because it's difficult or impossible because you're going to have 2 legal parents. And so I think that's what I would say. I'm not sure whether anybody else wants to add anything.
I think one of the things I mentioned was around a child's right to know about their origins. So that's something that's worth considering in widening the scope.
Yep. I mean, I would say this is wholly about children's rights, that they are connected with these people who are acting as their parents, and the children have rights to be financially maintained by them, absolutely, to inherit their nationality, to have that legal connection with them. It's not just about what's in the parents' interests, it's about the children's realities and recognising those realities in law. And I think it's one of those things that most families, most children, will just take for granted the fact that they have a legal connection with their parents. They don't have to think about it. And I find that many family lawyers think about parental responsibility because in most traditional family cases, legal parenthood is just a given. So it is about those families where children lack that legal connection and giving them that same status that other children being raised in more traditional families enjoy without thought.
To be fair, I don't know if anyone on this side would wish to contribute on that point.
Against or for?
Well,
we're still against.
You're still in role.
Well, I mean, the point of children's rights was one of the points I think we all touched on to some extent, and one of our arguments for the against camp is that the arguments for reform are all framed and couched in terms of parental rights and different and the adults wanting to feel a sense of them being recognised. And there is, we would say, Maud, a risk that the children get completely lost in that discussion, as I would say was the case in everything you heard from the for camp.
I think the reality is, if I may, Simon, that we've done a lot of work on what children in sort of non-traditional families think and feel, and that's what you heard me present this evening.
Thank you.
I think I might add just one thing to that, which is the elephant in the room is not the shared, open family arrangement, but the one where you have parents who are determined not to let their child know their biological origins and where their origins are. And I think that's one difficulty with arguments which allow for a widening. May conversely encourage those parents who are determined to be deceptive to go elsewhere in terms of surrogacy arrangements. So that does need to be thought about.
And if I may also,
Yeah.
and if I may also add, I have tried also to focus on my speech precisely on the child's viewpoint on this. And I just want to reiterate the point that if we put the children at the center of this debate, what the child cares for is who is actually caring for them. So any sort of movements throughout their life in terms of who is caring and taking part in the parental arrangement for the child would be better served by the legal toolkit that we have precisely for that reason. And it would be on the opposite side against the child's best interest to have legal parenthood suites throughout their life. And I also take the point that one of the speakers before made, that the idea would be to have it fixed before. And I'm not sure that that would solve everything, because as I understand it, a lot of the laws on multiple parenthood in Canadian jurisdictions or in US jurisdictions do center around changes that happen throughout a child's life and accommodating someone, for example, who has stepped into, for example, a new partner of their legal parent and has stepped into their role and recognizing parenthood for them. And I would say that those instances too would be better served by a quite different, but in many ways broader, more comprehensive tool that is parental responsibility.
Thank you. Any next question in the room? Yes, gentlemen at the back, at the far side. Sorry, Ash. It's important to use the mic because the people online can't hear.
Thank you very much. It was a question relating to a point that Simon made. I'm paraphrasing slightly, but you said if we make it easier for people to opt into being parents, then of course it will be easier for them to opt out. And you then referred to a case about a man who, after separation from his wife, obtained a declaration of non-parentage. I don't know the case. I'm assuming that was because the assumed basis of parentage, i.e. a biological relationship, turned out to be wrong. Is that right? He turned out not to be the biological father, I assume.
It is slightly more complicated than that for reasons I won't bore you with, but in essence, that was his argument, that he wasn't the biological father.
I just wonder if it wasn't obvious to me why that suggests that if you were to expand the concept of legal parenthood, there would be a sort of opt-out option. It seems to me that's quite a specific case, and also one that actually kind of foregrounds that presumed biological relationship to parentage. And I don't necessarily see why that would have to or have any implications really for legal parentage acquired through some of the routes that we've been talking about today.
I mean, one of the points that I didn't have time to touch on it was the fact that most children's legal parentage is determined by a series of rules, which means there isn't an awful lot of argument over it. The types of extensions that we're talking about largely today are orders, which are welfare based. But of course, the issue with orders is orders can be made and discharged. And that's why I say that's very different to a rule that has no get around. If you are a biological parent on the whole, you're the legal parent. If you start allowing 3, 4, 5 people, I don't think you've said 5, but I'm exaggerating. But if you allow multiple people to obtain orders, there must be a mechanism for those orders to be discharged. So I would say that you do run the risk of increasing opt-out.
I can respond to that. I wasn't proposing that there are orders necessary, that parentage always has to be created through orders. I think the proposal is that it's based on intention, and those people are parents from birth. So the point is that you're expanding the numbers of people who have financial responsibility. There would be no mechanism for getting out of that other than through an adoption order being made, just as is already the case now.
As in unregulated arrangements, that it would all be intention based?
Yes. Well, in relation to any child that was conceived through assisted conception, it would be about what was intended. And the best way of doing that would be through regulated pathways where there were legal advice, agreements, clinic counselling, forms, etc. But essentially the principle is that it's intention and that the people who intend to be the parents are the parents. And that is then fixed throughout their lifetimes unless an adoption order is made to take that parenthood away.
Can I counterpoint to that? I would say that also to come back to the previous question about a child-focused approach to the matter, that ultimately what the law is concerned with is not entirely what the prospective parents want or what the prospective parents would wish for, that there is no positive right in that sense to become a parent through any pathway that would be the most appropriate in that case. And that indeed the legal system of parenthood, what it puts at its center, it's basically designating the people who bear the ultimate responsibility and commitment for the child. And I think that in our previous quite heteronormative system, that was mostly biology and marriage, but that always stood as a proxy for assuming that responsibility, and that under our assisted reproduction framework, intention as a more appropriate basis has taken on that role. But in every case, it always functions as a proxy for who is responsible ultimately for the child. So I think if we do move towards a purely intention-based system of parenthood, we would logically, reasonably need to accommodate something like what Simon says, that if the whole basis of it is intention, you would have to also allow for people to walk away from those responsibilities based on their intention alone. And I'm not sure that that is something that we want.
Something. I think there's seems to be a bit of an assumption that those families that are non-traditional are more likely to break down, or that if there are sort of multiple parents, there'll be more likely conflict, or that's simply not borne out by the evidence at this point.
I don't think that's a fair a characterization of what we're saying. I say this as a family practitioner that sees lots and lots and lots of heterosexual couples break down. I mean, I don't think anything we've said implies that different family structures are any more or less likely to remain together.
Or the idea about kind of somebody wanting to abdicate themselves of parental responsibility. I mean, the reality is for many families formed through assisted reproduction, their children are extremely wanted. And therefore, one might well imagine that you would see fewer instances of relinquishment of parental responsibility in those cases.
Right. Shall we move to someone online if we've got any questions online? Don't know who's doing that. Sophie.
I've got a question from Sheena Webb, one of our FJC members. I'm curious about whether any change or non-change in the law would affect parents' and children's rights where care proceedings are issued.
Right. Technical question. So that's open house to anybody, really.
I'll have an attempt. But potentially, I mean, I suppose if you were to adopt the approach that Natalie invites, where there would be intention from the get-go, presumably it'd also be the state that those three people, for example, would also have parental responsibility. And so if there were care proceedings in respect of a child born who had three parents, then they would be respondents in an application for a form of public law order. And that to me seems right, because plainly if the question of whether the child's at significant risk of harm is one thing, but it's the parents who have to respond to it, and the extent to which one of the three parents might have been the parent who had placed the child in harm, the others still have to kind of respond to it. So I don't think it might mean there are more people in the proceedings, but they would still have a right to be party to it.
Does anyone disagree with that? Well, I think you might have got it right. I've got another question.
I have another one from Sean Gissing McNeil. How does the expansion of legal parentage to multiple parents, particularly in the context of transgender rights, challenge the constitutional framework of the UK, including principles and the role of the Crown constitutional foundations tied to traditional family structures? That's a question about does it or doesn't it for the panel.
Yes.
But
What's to
Understand the question.
no, I think it's a big question. Do you want to read it again?
I can read it again, or I can go to another one. Whichever. How does or doesn't the expansion of legal parentage to multiple parents, particularly the context of transgender, challenge the constitutional framework of the UK, including principles and the role of Crown constitutional foundations tied to traditional family structures? What is it?
I think that's a difficult question
Too
to
difficult.
understand.
Yeah, we'll go to another one.
Yeah.
Should the restrictions, this is from Ruth A, should the restrictions of the current child maintenance system be a reason not to expand legal parentage? Should the focus be on family connections, not finances?
Deal with that. It's really, that you shouldn't have been concentrating on the money.
Yes.
This-
I feel like I'm in the Court of Appeal. I'm being asked a lot of questions on my argument. Well, I hope I answered that question in most of what I said, and I think the point that I was making was that to some extent there's a utilitarian point, because for the I think it's 1 million current applications before the Child Maintenance Service for whom there's no argument at all about who the legal parents are, but there's huge issues with non-payment, and there is an argument, I say, that given that we are dealing with a minority of children, to cause a ripple that could actually impact the vast majority and how easy it is to get money from another parent is quite fundamental in my view. I mean, I hear what's said, but ultimately love is important, but so is food, is my view.
If I may also offer some further defense to Simon's eloquent argument, I don't think the two are mutually exclusive. And I do think there is usually this tendency to put on rosy-eyed glasses, especially in family law matters, and just focus on the love and the emotions and the connection. But at the end of the day, also practical matters are important, matters of residence, financial issues, maintenance, they are just as important both to the children and the parents involved. So I don't think it's really a question of either or.
Anyone in the room? Yes.
Given, quite frankly, the eye-watering cost of fertility treatment in this country and the postcode lottery that is effectively in place, and I say this as a trustee of a women's health charity as well as a family lawyer, how does the panel either side feel that actually widening the scope of legal parenthood would allow actually some access to justice for families who quite simply have gone through fertility treatment and then face, quite frankly, eye-watering legal bills afterwards as well?
Eye-watering legal bills.
As well as the eye-watering fertility treatment bills.
Right.
Okay.
Yeah.
I
Dafni?
think that's a great question for the against camp, because restricting the number of parents to just 2 might actually give some traction to campaigns that advocate for publicly funded treatment for all those that need it, so that they wouldn't be subject to the postcode lottery.
Natalie.
I would just say, I mean, there are lots of different situations, but if you take, for example, the situation of surrogacy, at the moment, every parent who has a child through surrogacy has to follow a legal process after that child is born. Some parents self-represent, others instruct lawyers, and there is cost involved in that process. What I'm advocating for is recognizing the right people as parents from the beginning without needing to go through that costly and expensive and lengthy legal process. So actually it would reduce cost for those who have struggled to have those much wanted families.
There's one point I'd like to make too, which is looking at some of the statistics on the relative incomes between intending parents and surrogates. There does seem to be a real difference, with surrogates being in the lower income brackets and intending parents being in the higher income brackets. And there has to be a concern that if the law changes to attract more families to try to use surrogates, one can't help wondering whether it will actually force people into the unregulated market to save money. And that is a risk for children.
Just there's an awful lot to say about that, but I think myths are being perpetuated about how surrogacy operates and the profile of surrogates, which doesn't reflect the reality, certainly of the surrogates that we see in the UK. And I think there's a bigger global picture here as well, because the lack of availability of a proper system for surrogacy in this country is driving parents to go abroad. And some of those can afford to go to places like the States, where it's very well regulated and very safe and ethical, and there are lots of protections for surrogates. But other people who can't afford that are being driven to other countries where surrogacy is wholly unregulated. And actually, if we sit in the UK and say, well, we don't really like the idea of this, so let's bury our heads in the sand and we're not going to regulate it properly, we are exporting the concerns about exploitation of women and income differences. And it would be much better to have safeguards in place and allow it within a more liberal framework here in order to address those concerns.
And might I add to that, Natalie, that if one is focused on what is in children's best interest, that would be not to have such international examples that you've described, precisely because access to information is for some children very important.
Thank you. I think we've got one more question online and then one in the room, and then it'll be make your mind up time.
I've got one from Jen Lee. Should the law not be reformed to encompass and give proper reflection to all children in families of all forms? Does the rigid adherence to a normative two-parent concept risk undermining the true lived experience of these children?
Well, you'd all say yes.
Yes.
And you'd all say no. Does anyone want to say more than yes or no to that? I think it's a point well made, isn't it? It's from depending on which way you look at it. Yes, final question. Then you need the microphone because the people online can't hear.
Mainly a kind of point of clarification from Andrew, possibly also Natalie. So in relation to more open adoption, would the suggestion be that the birth parents continue to be legal parents, and then the adoptive parents are also legal parents, but they're legal parents with different status? And I wondered whether, if you have legal parents who have different status in that way, might that also in some contexts apply to surrogacy arrangements? So you have birth parents, birth mother, and then intending parents. So I was just wanting to clarify, are the birth parents in your open adoption model still legal parents, or are they some other sort of parent?
No, in my proposal, or what I suggested, would be that they would cease to be legal parents at the time of the making of the adoption order. So rather than having this legal fiction that says they were never the child's parents, it then becomes that the adopters or the adopter is the child's legal parents from the time of the order is made. I suppose the difference with surrogacy is that a parental order, although it's transformative in the same way that an adoption order is, it's reflecting what was intended, whereas the adoption order is replacing parenthood. And so the first half of the question, I suppose there could be a model whereby you could have a system where birth parents retain some form of legal status, but that would then change how it looks as an adoption. But I think actually, if you're trying to get to a situation where we're trying to encourage post-adoption contact, you need to remove this kind of taboo that says birth families are monsters, or they're bad people.
Certainly the proposal Andrew was referring to doesn't make the change you suggest, but there is a debate going on as to whether when an adoption order is made currently, the child is as if born to the adopters, and that ignores the reality biologically and also the legal reality that for 4 or 5 years the parents have been the legal parents, and so there may be some thought to be given to that. Anyway, next year's debate maybe. Right, how are we going to do this, Sophie?